All right, so recording now, probate 101 for realtors. So we're gonna just start by talking about what what probate is. So the word probate, um, unfortunately, you'll come across it when somebody has died, when somebody has passed away. So in order for there to be a quote unquote probate, somebody has to have passed away. Someone has to have died. Um, it involves the courts, it involves a judge, it's probably going to involve an attorney or two. And what we're doing is in your world, in real estate, what we're doing is we're taking a piece of property that somebody owned, we're going through a court process, and at the end of it, the judge is going to say who the owner of that real estate is. So commonly, John owns a piece of property, he dies, now his property is owned by his estate. In order for his kids to inherit the property, sell the property, rent the property, they've got to go through this probate process. And at the end, the judge is going to say who gets John's real estate. So whenever you think of probate, just know that someone has to have passed away. There had to have been a death, and we're transferring assets. We're taking what someone had while they were alive, and we're giving it to whoever their new to their children or their heirs or whoever that is. Decedent, and I'll email you guys these definitions as well. But I'm just going to give you a few that I think are useful for right now. Decedent. So a decedent is just someone who's passed away, right? Somebody who's passed away. Estate, 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 or like if you're saying state with a super thick Cuban accent, estate. Either or. So estate. So what that is basically everything that a person had when they were alive. So assets. So they had their house, they had their car, they maybe had a checking account with some money in it. They had their clothes, their jewelry. Those are all their assets, the things that they owned. They might have also had debts. They might have owed money to credit card companies. There might have been a mortgage. There might have been hospital bills. Those are all the liabilities. After they die, we refer to all of that stuff, the assets and the liabilities, as the estate. So if John Smith, all right, so John Smith was alive, we called him John Smith. Now that he's died, we call him the estate of John Smith, because John has died. So everything that he has, we talk about him as the estate of John Smith. Last will and testament. So you guys are probably familiar with what a will is. So a last will and testament, that's a piece of paper that says what happens to your stuff after you pass away, right? So I've got a piece of paper, I write on here, I want my wife to get this, I want my children to get this, I want my mom to get this. That's a will, right? And so we'll talk about wills and how they come into play a little bit as well. Personal representative. So personal representative, also called the executor, depends on the state. So for example, New York calls this person the executor. In Florida, we call them the personal representative. This is the person that you all are working with. It's the person I'm working with. So the personal representative is the person who is in charge of hiring the realtor, listing the property, signing the closing statement, signing the listing agreement. They're the person who I'm working with to do the entire process, right? So the personal representative, we're going to talk in great detail about that a little bit, but the personal representative is the person who you all need to be working with, right? That's because if you're working for the seller, that's the person who's going to get to hire you, is the personal representative. All right, let me pull up something real quick. So if you want to put in the box, in the chat box, what's one of the, so we're going to start now. How do you identify whether or not a property needs to go through probate? What would be one of the first things that you would do if someone calls you and says, hey, I've got this listing, I want to find, can you help me sell this? What would be one of the first things that you as the realtor would do? not including probate, just any property, that your run-of-the-mill property. Someone calls you, says, "Hey, I want to sell this property." They tell you, "Hey, 123 Main Street." Yeah, so check the deed, talk to the owners. You guys are trying to outsmart me here. So what you're going to do? Who owns title, right? Okay, so that's good, Candace. So what you're going to do is you want to find out who the owner of the property is, and probably what you're going to do is you're going to go to the property appraiser's website, the county, the tax roll, and you're going to look up the property, and you're going to try to find out who the owner is. So I'm going to try to share my screen and share an example real quick. Okay. So here we have, this is just a printout for property appraiser website. And here you're going to look at, here's the property and here's the owner. Okay. So owner, Maria Pichardo, EST of Maria Pichardo. Easy one. What do you all think that means, the EST of? State of. Yep, perfect. So 99% of the time, if you see that EST of after somebody's names, after somebody's name, it means that that person has passed away and probate has to be started. There's probably, maybe there's a time when that's not the case, but every time I've seen it, and like I said, 99% of the time, if you see that EST of after somebody's name, you cannot probably go list that property. You can't buy that property. You can't do anything until that probate process is done. So in that case, the example, Maria Pichardo was the owner of that property. She passed away, and now that property is owned by her estate. So before her kids, before anybody can sell it, before anybody can do anything with that property, they're going to have to hire somebody, a probate attorney, to go through that process. I get asked, a fair amount, well, how does the county know that the person had died? I can't give you an exact answer. The organization in Florida who records death certificate is named Vital Statistics. We've called them just out of curiosity, and they say that they will notify the county when somebody has died, and then the county will update the records to show that the person has passed away. However, Karen, how long does it take to update owner records? I've seen on there where the owner passed away years ago and the property they haven't changed it on the property records. And I've seen it where they passed away recently and it's been updated. So I can't give you an exact answer of how long it takes. I would say it's more common that it happens usually within a year. And the reason is because someone's living at the house, right? So let's say mom owned the property and daughter's living in the house with mom. Mom dies. It was her house in her name only. And she was getting the homestead exemption, right? So I'm going to assume everyone here knows what homestead is, but homestead in Florida, basically it's a tax exemption that you can get if it's your primary residence, meaning you can essentially pay less taxes. But when mom dies, daughter does not get that homestead exemption anymore. So the county, when they find out that mom died, they're going to remove that homestead exemption. And even though daughter's living in that property, she can't get the homestead exemption until she gets the property put in her name. So a lot of times what I see is the person living in the house will go to the county and they'll say, look, my mom died. Here's a copy of the death certificate. Here's a copy of the will. Here's a copy of her title, whatever. I live there. Let me get the homestead exemption. And the county, in a not very nice way, will probably say, sorry, but you're going to have to go through probate and we're taking away your homestead exemption, right? So sometimes that's how they get notified, is by the person themselves. They'll go to the county and they'll say that, because if mom died in 2019 and now 2020 taxes, or 2019 taxes, or passes in 2018 and 2019 taxes are due, she wants that lower exemption, so she goes to the county. So anyways, that's a really long answer for, I can't tell you exactly when they update it, but they, you know, they know somehow. So but they do that estate of, if you see that, again, that's probably the most common way that you're going to know whether or not probate's going to be necessary. That should start your process. So next example, show you guys. Okay. So right here, second example, you've got owner of Jesus Silva, and then you've got EST of, and you've got Maida Silva. Again, this is pretty common most places, but definitely here in South Florida, where you've got two owners on title. And we're going to talk about deeds and how you can own property and whatnot and avoid probate. But this one, they just own the property in a way that's called tenants in common, which what that means is Jesus owned 50% of the property and Maida owned 50% of the property. Jesus was the father of Maida. Jesus was not married. He did not have any children, and he passed away. And this was, I believe this was an investment property. So Maida thought when Jesus died, she wanted to sell the property. So she gets a realtor, they list the property, they go through the entire process, they get a buyer, they go to title, and then the title company says, wait, did you do a probate for Jesus? And she's like, no, I didn't know, you know, it's my dad. We own the property together. He doesn't have any kids, wasn't married. And so she thought she could just sell the property. Well, she couldn't, because they only own the property as tenants in common, which again means he owned 50%, she owned 50%. So she's upset because they spent all this time, and now the buyer's upset because we got to go through the entire probate process. So this happens a lot, actually, where the realtor just doesn't know. Maybe the realtor doesn't look at the title and see that EST of. Maybe it wasn't on there at first. Maybe the client didn't say Jesus has died. I would think at some point that comes up in the conversation, right? I would think at some point, you know, you're doing your due diligence, you look up the property, and you would find that at some point, hopefully before the closing table, before going through the entire process. But this does happen because, you know, logically it would just kind of make sense. Like, me and my dad own this property, doesn't have any children, he's not married, it's, you know, it's mine, he passed away, so now I get it. But legally, you know, you guys know that's not how it works. So whenever you're speaking with somebody, obviously, if they say, hey, the owner passed away, or the person I'm on title with passed away, obviously that should kind of get you guys thinking about, you know, what needs to happen, if you need to go through the probate process, do a little bit more digging or whatnot. And certainly, again, if you see that EST of after a person's name, know that probate's likely necessary. The probate might be started, right? So just because you see that EST of, so for example, in those first two examples that I showed you, and we're talking about right now, my office handled the probates for both of them. That EST of, each of those probates, you know, lasted a couple months, and that EST of stayed on that title until we changed the deed, until we changed title once the probate process was over. So you might be looking at a property and you see that EST of on there. It doesn't mean the probate has not been started. It just means that probate's likely necessary. So if you see that EST of, again, you can go to, you know, it would take a little bit of work for you to find if the probate is opened, right? Like, you could probably figure it out by searching court documents. If you know how to do that, you go to the county website and search, you could find that. It gets difficult even for me if you've got like a Juan Rodriguez or something, you know, very common. That makes it a little bit more difficult, but you could still find out. So anyways, I just say that because just because that EST is on there doesn't mean that probate hasn't been started. Just know that it has to happen before you can do anything with it. So, all right. So now we talk the tenants in common. That's how Jesus and how Maida owned this piece of property, how could they have avoided that? Well, there's a couple ways, essentially by changing the deed. That's the easiest way for people with property to avoid the probate process, is by actually changing the deed. So husband and wife, if husband and wife are both on the title, if husband dies, wife does not need to go through probate for her husband in order to get the property in her name. She automatically gets the property. The legal term is tenants in the entirety. You probably don't need to know that. But husband and wife, if husband and wife are both on there, then if either one of them die, the surviving spouse is going to inherit the property automatically, and you don't have to go through the probate process to change the deed. Where this comes up sometimes, though, and it's just something to be aware of, is, and this is done often in older deeds, where they don't, for whatever reason, they don't put both of the people on the title. And I've seen it go both ways. Sometimes the underwriter, so the question, what if husband is only on title? Yeah, so sometimes I've seen that come up where it says a married man, or sometimes it just says the husband's name. It doesn't even list. Most of the time, if that's the way the deed's done, you're going to have to do probate. Most of the time, there's some ways around that. There's what's called an affidavit of continuous marriage. This is where, your attorney's going to, have to earn his or her money to make it work. But if it's just husband and wife, normal, me and my wife on property and both of our names are on there. If I die, she gets the property. No issues there. The other one is you probably heard joint tenants with right of survivorship. Okay, so that's a way to own property that avoids probate. So usually what you'll have on there is you'll have several people on a piece of property, right? Either as an investment property, or either as an investment property, or as brothers and sisters maybe inherited a piece of property, something like that. If both people, if it has that language, so let's say John and Sarah as joint tenants with right of survivorship, that means that if John dies, his property goes to Sarah. His 50% goes to Sarah. If Sarah dies, her 50% goes to John. So if you've got two people or three people, usually it's going to be two people. I mean, it could be more, but it's got to have that language as joint tenants with right of survivorship. If you don't have that language, then you have an example of that deed that I just showed you with Maida and Jesus, where they just own the property 50%. And when one of them dies, you have to do a probate for the other person. So joint tenants with the right of survivorship, very useful, very, very, it can be good. The problem with it is, I'll get into some problems with it here in a little bit. The other deed that I'll mention, which is kind of a popular one, is a ladybird deed, or what's called an enhanced life estate deed. Okay, so enhanced life estate deed. So there's two deeds. One of them is called a life estate deed, which means that I own a piece of property, but when I die, I want to leave the property to somebody else. Okay, they don't necessarily own the property. To some extent they do, but when I die, so let's say I want to leave a property to my brother. Okay, but I don't want to put him on title just yet. So I say, I, Justin Stivers, own this property, and when I die, my brother John gets the property. So when I die, John automatically gets it. He doesn't have to go through probate. That's good. That's a good option to avoid probate. But one of the issues with that is, what if I decide I don't want to give John the property? What if I decide I don't like John, or I don't like John's wife, or whatever? But now once he's on the deed with me, I need his permission to get him off. So Florida is one of a handful of states that has this deed called an enhanced life estate deed, or what most people refer to as a ladybird deed. Ladybird deed. If you go to our website, probatefirm.com, I wrote an article on it, a blog article on it. You can learn more about it. But what that is it's the same type of deed. Okay, it's the same type of deed that I leave the property to John, my brother, when I die. But if I decide I don't like John's wife and I don't like John, I can take John off of that deed, and I don't need his permission. I still keep full ownership of that property. John gets it if I do pass away, but if between now and me passing away, I take John off of it, no issues there. I can do that. So that's a really useful deed for that a lot of people, again, like everything, there are some pros and cons, tax consequences and different things, which we're not going to get into here. But as far as avoiding probate, if you do a deed like that, if you do the Ladybird deed, it's a useful tool. Another good way to avoid, so we're talking about how you can avoid probate, is by setting up a trust. Okay, so I'm going to give you guys an example of a trust right now. Okay, so here, if you look at the owner, we've got Karen S. Rodman, TRS, which stands for trust, and Karen Rodman, the daughter, as a beneficiary. Okay, so in this case, this deed was changed. It was transferred. Let me see. It will show on here. So it looks like this was probably it. So this is when they purchased the property, and then it was originally just in Karen's name, and then Karen did a trust, and she transferred the property from herself to the Karen S. Rodman Trust. So in this case, the owner of this property is the trust. She has a trust, and that's who actually owns the property. She's named Karen as the beneficiary. So when Karen Jr., when Karen Sr. passes away, Karen Jr. here as the beneficiary automatically gets the property. She does not have to go through the probate process because she's already on title. Now, I didn't do this one. This was a little odd, and I don't really know why, but you don't normally put the beneficiary on the trust. It's on the property appraiser's website itself. So I'm not sure why the beneficiary is listed. That's not common because sometimes you want to keep that private, but for whatever reason, it's on there. This is a way to avoid probate, setting up a trust. So I'll talk a little bit about a trust. I always get a lot of questions about trust. Having a trust, does it affect the mortgage loan? For homestead purposes, no. For homestead purposes, there's language. A trust is definitely not a do-it-yourself thing, right? So it's definitely not something you want to, because there's certain language that can mess up homestead rights. Generally, if you've got a mortgage on your homestead property, it's not going to affect it, but you got to put certain language. Investment properties might have an issue. It depends. Most lenders are okay with trust. They get the purpose of trust, and it doesn't really constitute like a change in ownership necessarily, because you still keep the property. But again, something to know before you just start doing this on your own. But a trust is, so we create first the actual trust document, right? So that's the document. This is the trust. So I create a trust called the Justin Stivers Trust. All right, that's step number one. So let's as an example, let's say that before I created the trust, I own 123 Main Street. All right, I own that property in my name alone. So I create the trust. That's step number one. Step number two is now I have to transfer the property 123 Main Street from myself to the trust. So I have to do a new deed. I actually have to transfer the property, do a new deed, transfer the property from myself to the trust. Otherwise, if all I do is step number one, all I do is create a trust and say, hey, I want, my brother to get my property at 123 Main Street, but I don't change the title, I don't change the deed, he's going to have to go through probate. He'll still get it because I left him the property, but he's going to have to go through probate first. So that's where a lot of people do it yourself, or even attorneys, frankly, mess this up, is they'll create the trust for the client, but they don't create the new deed and they don't transfer it. And then when they die, their kids are like, upset because they're like, hey, why did my mom spend this money on a trust and I still have to go through probate? Well, somebody messed up. Might have been the attorney, might have been the client, someone messed up, and they didn't actually transfer the property. So trust, again, if done properly, are great tools to avoid probate. Another thing I'll say about trust is, they're, for real estate, I think they're great. For real estate, I think that, a lot of times we get calls from clients or prospective clients, and they'll say, no, I just want to do a will. And I'm going to talk about wills here in a second. And then if I mention the word trust, there's kind of a, misconception that they're only for the super, super wealthy, right? So I'll say, I'll recommend a trust, maybe like, oh, I don't have any money. Doesn't make sense. Well, that might be the case. If you own real estate, I think there's a benefit, which we've kind of talked about right now, because it avoids probate, right? So that's a major benefit. If you're concerned about your family having to go through the probate process, having a trust is a great option, because now they don't have to hire an attorney, go through the legal process. One of the things that we do in our trusts is, let's say that you have 3 children and you want your 3 children to get the property. Okay, I have 3 sisters. Actually, I don't have a brother. I just use it as an example. I have 3 sisters. We get along great, but I can't necessarily imagine the 4 of us owning anything, but owning a piece of real estate together, right? Because you've got maybe one sibling's doing better than the other, maybe one's doing worse, maybe one lives in the house, wants to live in the house, lives in different state, so there's a whole bunch of things that could happen if you put a bunch of people on title. So one of the things that we do a lot for our clients is we'll say, okay, you want the property to go to your 3 children? Great. Let's do a trust. Let's set up a trust, and let's name one of the person in charge, one of the kids in charge. He or she is going to ask that an independent after you all pass away, is going to ask that an independent appraiser come out, do an appraisal on the property. So now you've got an unbiased amount. So the appraiser says it's worth X amount. Doesn't matter what the other kids say, it's worth this. Then the other kids have 90 days, or we can say 120 days, to get a mortgage and purchase the property themselves if they want it. If they don't, then the person in charge of managing the trust is going to hire an independent realtor, right? Not a family friend who's a realtor, someone independent, to come and list the property. And then they'll split the proceeds 3 ways. That way you don't have 3 people owning title. Who's going to pay property taxes? Who's going to manage the property, maintain the property, and all of that? So a trust is a great way if you're trying to leave property to somebody. And the last thing I'll say about the trust is it's also good for minor children. If you've got young kids, and you want to make sure, if something were to happen to both of the parents, who would take care of the children, right? What I've seen, unfortunately, is now you've got, if something happens to both of the parents, who's going to take care of the kid? Which set of in-laws, right? Most of us aren't blessed with having 2 great sets of parents on both sides. So now you've got a potentially a fight between the in-laws over who's going to get custody of the minor children. So anyways, it's a great tool for that. And then, someone put in here, asset protection. So so then there's protection for, for liabilities, for lawsuits and things like that. So those are all good reasons for trust. But the main reason I'm talking about trust right now is that it's a way to avoid probate. 2 things that do not avoid probate: a will. So see if I have a copy. If you can see this is a copy of my business card. I don't know if you can see it, but at the top of it says, "Did you know that having a will does not avoid probate?" So a lot of times, a lot of people think mistakenly that having a will avoids probate. So they'll come to my office and they'll say, "Look, my mom did a will. Why can't I just go, and she left me the property. Why can't I just go get the property put in my name?" Unfortunately, because that's the law. Unfortunately, because that's the law, it doesn't avoid probate. So this happens a lot, where because you can go online, you can do a will yourself pretty cheap, and some of them are fine. There's no reason. I'm not knocking a do-it-yourself will. I think some of them can be just fine. if you know that they're not going to avoid probate, right? So, and a lot of times people don't know that. They'll create a will. They'll say, I want to leave the property to my 2 children. Mom dies. The children go with a copy of the will. It's original. It's legitimate. It's done properly. They go to the court. They go to the property county property appraiser. Say, look, this is my mom's will. Put the property in our name, and the county is going to say, unfortunately, you've got to hire an attorney and go through probate. So, a will has some value. There are legitimate reasons for doing a will. I still think everybody should have a will, but just know that if one of your goals in doing any of this is to avoid probate, or for your clients, or for your client's matter, sake, it does not avoid probate. And that's really what we're talking about. If a client shows you, hey, look, the property, my mom left me the property, don't just think that they automatically get the property, right? So we're probably going to have to go through the probate process. And lastly, about when is probate necessary and when's it not probate. LLCs, obviously very common here in South Florida. A lot of foreign investors, people purchase properties. An LLC does not avoid probate. So if you've got a client, Francisco, in Argentina, and he buys a couple properties here, on Brickell Key or, South Beach, wherever, and he wants to put the property in an LLC, that's great. There's pros to it. I have nothing. I support LLCs because there's tax protection, benefits, liability, all of that. They're great. However, when Francisco dies, his children are in Argentina, who owns that LLC? Francisco did, right? So now Francisco's kids in Argentina are going to have to hire an attorney in Miami to get the property put in their name. So how do you get around that? A couple different things. You number one, if you're setting up an LLC, you could do what's called an operating agreement that says what happens if the owner dies, right? So when you set up that LLC, you say, when I die, I want my children to take over the property or something like that. That's option number one. Option number two is you could make the trust the owner of the LLC, a little bit more complex, but that's another option as well. So again, just a couple options that, just a couple things to know with the LLCs. Just because you've got an investor and it's in an LLC or whatnot, might be a good idea, but it's probably not going to just avoid probate by itself. All right, so that's how we're looking at whether or not a probate's necessary. So I'm going to try to, I took a little bit longer on that than usual, but I'm going to try to rush through some of this next bit of it. All right, so when you've, so let's say now that, that we've determined that probate's necessary, right? So we've seen that a state of, we know that the property is owned by someone who passed away. Now we're going to go meet with the client. Remember when I said, in the beginning, the personal representative is the most important person that that for you all to know, because that's the person who gets to, frankly, pick the realtor. So in probate, the personal representative is appointed by the court. Okay. So if we have to go to court and ask for somebody to be named as the representative, and the judge is going to sign a piece of paper saying who the representative is. So even if your client has a will and says, look, my mom named me as the representative, that's not good enough. It might be good enough, but I'm going to have to take that will and go to court, show the judge it's a valid will, and then the judge, he or she, is going to have to name the person as the representative. And the reason is, I could give you a ton of stories, but I've seen where there's two wills, right? So will number one was done in 1990. Mom made one person representative. Will number two was done in the year 2000 and named somebody else as representative, but mom had Alzheimer's in year 2000, right? So she couldn't have made that will. So if you go and see will number two that was done in the year 2000, naming somebody else as representative, that will might not be valid. So your job is not to determine whether or not the will is valid. That's my will. That's my job. But your job is just to know that until we get this piece of paper from the court naming who the representative is, that's when you can start working with them. And that's the person who's going to hire the realtor um, to do the entire process. I saw that question once before. Can the PR be an heir of the estate? So can the personal representative be someone who's going to benefit? Can it be a child? Yeah, often it is. 99% of the time, it's somebody who's going to benefit, who's going to receive the property. No issue with that. So when you go meet with this prospective, let's say it's for a listing. When you go meet with this prospective client, how do you determine whether or not it's going to be the representative? Obviously, if it's already in probate and there's already an attorney involved and they've given you the piece of paper and you know it's the representative, no issue there. You already know that. But let's say that this person just died, there's no estate open, and they called you and you want to meet with them. I usually recommend a couple different things. First, ask them if the person had a will, right? Ask them. So you go to John's house. John, did your mom have a will? Okay, she did. Great. Okay, your job is, again, not to determine whether or not there's the will, but sometimes the will names somebody else as representative. Let's say you go meet with John and John's mom had a will, but the will named his sister Anna as a representative. Well, John's probably not going to be the one who's going to hire you. Anna is. So we want to make sure that you're speaking with the right person so that you're not wasting your time. So ask them if they have a will. Second, do they have a copy of it, right? The reason is there are no oral or verbal wills in Florida. So just because dad tells someone, hey, I want you to get everything that I had, that's not good enough. It has to be in writing, and we need to have a copy of it. It's okay if we lose the original. Makes my job a little bit harder, but that's okay. We can deal with that. But they need to have some sort of copy of it. So did they have a will, and can you get a copy of it? The next question we want to ask is, what's your relationship to the person who died, right? Was this your mom? Was this your brother? Was this your tío? Was this your tía? Like, who was this? Okay. And the reason is the closer in relationship without a will, the more likely this person gets to be the representative. So in Florida, if there is no will, there's a hierarchy of who gets what. First it's the children. First it's the spouse, then it's the children, then it's the parents, then it's the brothers and sisters, the grandparents and cousins, and until you get out to second and third, fourth cousin, right? Most of the time, I can't say all the time because I represent clients that are second and third cousins of like third removed from the grandmother. So very distant, very, very distant. That happens, but that's not that common. Most of the time, there's going to be a brother, a sister, a parent, somebody, you know. So if you're speaking with somebody and they're like, this is my mom, this was my dad, this was my brother, chances are they have a chance of being the representative. But if you're speaking with, you know, the cousin who nobody's ever heard from, you know, several, you know, many, very far removed, not saying that it's not possible, but just not as likely. So we want to know who we're talking with. All right. So now let's talk a little bit about the process, right? So now, again, let's say that you brought your attorney in, or the attorney's reviewed it. The person you're speaking with, we're pretty sure is going to be the representative. This is the person that, you know, they can hire you. How do they sign things, right? So how can they hire you? Well, if the property is owned by their parents or their mom, can they sign the listing agreement? Technically, no. Until they become the representative, they can't really sign the listing agreement, right? Once they get appointed as the representative, now they can sign the listing agreement. So one of the things that I see done, and I think it's worked well, and I haven't had any issues with it, is let's say that you go meet with this prospective client today, okay? But now it's going to take, on average, about 30 days to get them appointed as representative, okay? So I'll talk about length of time here in a minute, but if someone comes to my office today, they hire us today, they fill out all the paperwork today, we get a court case today, it's probably going to take about 30 to 45 days before we actually get that piece of paper and naming them as representative. If they come see you today, you probably don't want to tell them, oh, you're not the representative, come back to me in 45 days. Because they're going to go to Century 21 next door, EWM right next door, Caldwell Banker right next door, Beach, all these different places, and they're going to find a realtor, right, who will represent them right then and there. So what I have seen done, and I have no issue with it, but ask your broker, is when you sign the listing agreement, you have them sign it as the proposed personal representative. Okay, so John Smith as the proposed personal representative. They're not yet the representative. We're pretty sure they're going to be the representative, but they're just not yet the representative. This way, now you have, kind of something in writing that says that, that they're hiring you, even if it's not 100% foolproof. If they wanted to come back on the contract, maybe they could. I've never seen that happen, but in theory, I suppose it's possible. But at least you have it in writing, right? Once you have that, though, if they're not the representative, don't go list the property yet. You can't put it on the MLS. You can't put up door hangers, yard signs, anything like that. You have to wait until we get them appointed as the representative. Once now I come back to you and I say, look, John, here's the court named you as the representative. At that point, now the realtor can list the property, put it on the MLS, do all your marketing and everything. But until we get that person appointed as the representative, we're not going to list it just yet. Once the person gets appointed as the representative, now when we go to contract and we sign that as his contract, he's going to sign it as the personal representative. We're probably going to update the listing agreement as well, just to be, cover all our bases. And so now John's going to sign everything as John Smith as the personal representative, right? Once we get him named as the personal representative, now you can sell it. Now you can list it. Okay. We might not be able to actually go through contracting, go to closing yet. And that brings us to kind of length of time. So there's two situations that determine how long the probate process is going to take. It depends on when the person died and when we start the process. Okay. I know this is a ton of information. That's why I'm recording it. So yeah, I'm going to send it to you guys so you can come back and watch it and whatnot. But two situations. If the person died more than 2 years ago, okay, so let's say that the person died in 2017 and we're in 2020 right now, 3 years ago, it's probably going to take about 3 to 4 months. Okay. It's going to take us, like I said, about 30 days to get them named as the representative. So that's month one. After month one, now that we've got the representative appointed, now you get to list the property. Month two, you guys are free to sell it. All right. You guys can go to contract, go to closing. If after 30 days, August 1st, we get appointed personal representative, September 1st or August 2nd, you can go ahead and list it. August 3rd, you've got a contract, great, go to sell. So about 30 days to get the representative appointed, and then you guys can list the property. And then it's probably, in my world, in the probate world, we're probably going to have to keep the probate open for another 60 days or so. So the entire process is probably going to be about 3 to 4 months. But for you all, if the person died more than 2 years ago, we start the probate, probably within 2 months, you all can sell it. If the person died more recently, which is more common, right? So most people start the probate process relatively soon after someone has died. So someone died in 2019 or in 2020, and we open the probate process, it's probably going to take 6 to 7 months, okay? Same thing. First 30 days, it's going to take us to get the representative appointed, right? So August 1st, we get the representative appointed. Now we have to wait 90 days. So there's a creditor period in Florida that they have 90 days to notify me, the attorney, and say that the person who died owed them money. So Visa, Baptist Health, Palmetto Hospital, American Express, Home Depot, wherever that owed money, they have a 90-day window to come and notify me, the attorney, that they are owed money. Then I'll send, we object to them, we fight them and whatnot. So 30 days to get the representative appointed, then month 2, month 3, and month 4, we're waiting for that 90-day creditor period to end, Then month 5, now you guys can sell the property. After the representative has been appointed, right, you all are free to list it, go under contract. Just know, most likely, we're going to have to tell that buyer, we're going to have to wait 90 days before we can actually close on it, which I know scares a lot of people off. So if this is a client who's selling their house and they need to get into another house right away, I would probably say this is not a great deal for you, right? Because we got to wait this time. If they love the property, they're okay with waiting, they trust the attorney doing it, they, whatever, they feel comfortable with it, great. That happen, this happens all the time. 90% of our probates involve a piece of property, and a lot of them get sold, and they're okay. They're okay waiting that period. Just know, for you guys, you can list it, you can go under contract, but we got to wait for that creditor period to end, which is probably going to be around month 5. So now around month 6, so around month 5, month 6, property gets sold. Month 7, we're able to close out the probate. So a lot of information there, but relatively simple. Two options. If the person died more than 2 years ago, it's probably going to be about 3 to 4 months. If the person died more recently, it's probably going to be 6 to 7 months, more or less. Again, if you can probably sell it a little bit sooner, but the entire process is probably going to be around that long. All right, and then last kind of thing that maybe I'll touch on, because I saw a question, and this is kind of, I know we're running up on our clock, our time here, but so how do you find probate listings, right? So how do you get listings? How do you come across it? Frankly, you can buy lists. So actually, this is kind of let me see if I can find a copy of this. So I already went into my trash. Someone mailed me something. Someone mailed me something today that I got. It was from a realtor, and I'm actually named as the representative. Let's see if I can find this for you guys. Okay, I don't want to call them out because maybe they're on this call. Actually, this is in Orlando, so probably not. So someone sent me this letter. So I'm named as the representative in this, and it said, "Dear Justin, as a newly appointed representative, you may feel as though you are facing an unclimbable mountain. If you're hoping to find a trusted probate advisor that will walk you through the entire process, I'd love to talk with you and your family to determine how I can help you every step of the way." Yada, yada, yada. Not a bad letter. That's fine. I don't have any issue with that. It's just, I'm not a good market for him because I'm too busy. I work with a lot of realtors. Like I'm probably not gonna hire like someone random who just sends me a letter. Like, it could work for me personally. So I'm not saying don't do it, try it, but for me personally, it's probably not gonna work. But for the consumer, for the client who maybe doesn't even know what probate is, maybe doesn't even know that they need to go through the process, it could be a good tactic. So I'm not knocking, A for effort, right? But you might want to, so you can get that information. So he found me because he saw that I'm a representative in court. This means that this probate had already been opened, and that information is public. So he found me and saw that it involved a piece of real estate, and so you could go about it that way. That's probably the easiest way, or an easy way. And I don't get too many of these, right? There's like 3 people who will email me pretty regularly, which again, there's 100 plus people on this call. There's 55,000 realtors in Miami, and to only be getting one email, or one letter, that's pretty good odds for you guys. So I think there is some potential there. Networking, obviously difficult right now because we can't see people in person, but meeting other probate attorneys like myself who handle a bunch of probates can be good referral sources for you, because again, I'm not going to work with this person, but I do have realtors that I'm working with, because I'd rather work with my people that I know well, that I know take care of my clients, et cetera, et cetera. Sometimes I have the opportunity to refer clients to someone. So I would try try to target probate probate listings, or probate attorneys as well. Could be an opportunity as well. All right, I saw a lot of questions, so if you've got one, I've got another couple of minutes. I can, like I said, I know a lot of people have been emailing me. I'm gonna give you guys the link to this. Give me, probably be another couple of days, and I'll send you all the link so you guys can come back and watch it. My information, you'll have it in my email when I send it, but probatefirm.com, that's probably the best way to get our contact information. Just www.probatefirm.com. Justin Stivers is my name, the probate law firm. Let me scroll up and see if there's any questions that make sense. If you've got one, put it in there. Is there any specific clause to put in the listing when it is probate? I don't know. That's not a question I necessarily know. Like on the MLS, maybe you're talking about. I'm not sure if you've got to put that on there. In the as-is contract, normally, like you have, I don't know, it's like paragraph 8 or paragraph 11, I don't remember, like that info sheet where you can put additional information. I'll usually tell the realtor, hey, just put subject to probate, subject to probate court approval, and then I'll put the court number or something like that. Very, very simple. But as to the actual like listing, I maybe ask your broker. I'm not entirely sure about that. Creditors charging late fees. Yeah, they might, but so the question is, if someone dies and they owe money to Visa, can Visa charge late fees? Probably not. I haven't seen that, and if I did see that, part of my process is we object to all the creditors and try not to have to pay them anything. One thing I didn't mention, this is just kind of useful knowledge. If you've got a loved one or a client and their loved one passed away and that person owed money to Baptist, to Visa or whatnot, you or that person is not personally liable for those debts, right? So you don't need to come out of pocket to pay those, right? The debts are with the person who passed away. And so you don't have to pay for those. And actually I encourage you not to, right? Like, so if a client comes to me and they're like, hey, I'm getting these bills, I say, well, don't come out of pocket just yet. Like, let me see everything. Don't just start paying them. And I've, most of the time we get those debts removed. So credit cards, 95% of the time. Hospital bills, we get reduced. And unfortunately, a lot of times my client will come to me and they say, oh, I paid the $8,000-$10,000 credit card bill. And I'm like, well, I'm sorry. It's good. I mean, it's fine that you paid it, but you probably didn't have to. Let me see. Yeah, there's a lot of questions on foreign stuff, which is common. Here in South Florida, when the properties go to probate, but the heirs are in Florida, do they need to be present in Florida for the court's probate process? No. Most of my clients I've never met in person. 99% of my clients I've never met in person. I do a lot of work with out-of-state people, so a lot, and foreigners, New York, New Jersey, Michigan, California, retirement places, and they don't have to come to court. They don't have to do anything like that. Questions about LLCs, operating agreement, it can avoid probate. So remember, it's if done properly, if you do an operating agreement, if you do a trust, there's a way to avoid probate. Definitely not a do it yourself thing. All right, I'll take one or more before I have to jump off here. Let me see. If they own a house, are you still able to get the credit cards removed? So the debts are attached to the person themselves, right? So if you are not on the account with somebody else, right? Like they pulled your credit with that person when you got the credit card, you're not responsible. Houses are, they're credit card companies. I've never seen them go after a house, right? Even though I've seen credit card bills of $50, $100, $150,000, they're not going to go after the house. And your homestead is protected, right? So your primary residence, your house, is protected from creditors. So so you're not going to have to do that. All right, I think. All right, and then there were a couple questions just about, you know, how the attorney charges. Um, they can charge flat fee, which is generally what we do, is one price for the entire process. They can charge hourly, or you could charge a percentage, right? And so some attorneys will do that. But um, thank you guys. I know we're a little bit over, so I want to respect your time. I appreciate you guys. You know, we held strong. Most people stayed till the end, so that's awesome. Like I said, be on the lookout. Next couple of days, I'll email you all links and a couple of the handouts that I went over today. Thank you guys. Have a lovely Monday. Appreciate it. Talk to you guys soon.